improve our audience background. But some of them may not know necessarily, aren't lawyers or aren't with law degrees, right? And so just really basic, like cross-examination. If you were just going to simplify it, what's a cross-examination?
It's just asking questions to the other person's witnesses.
Yeah.
So if we're talking criminal cases, it'll often be the cop that we're cross-examining. It might be the medical examiner or a state's expert. It might be the witnesses, because usually in our criminal cases, witnesses are not good for us.
Sure.
Oftentimes witnesses are co-defendants.
Citizen witnesses of some sort.
That's right. It's people who saw what happened.
Yep.
Or it might be the victim or the alleged victim if there hadn't been a conviction yet. And we're talking to people who have accused our clients of very, very bad things.
So when you're, what I think of is typically adverse witnesses. I know we'll get into it, and sometimes maybe we can make those adverse witnesses our witnesses.
That's right.
But you're going into a scenario in which you're asking somebody who's adverse to your goals.
Yeah.
Some questions, right?
That's right.
Are there just some general things that you think about as like in general when I'm going into this situation where I need to try to get some information, some facts from somebody who's adverse to it? What do you do?
And I think you hit the nail on the head. You're looking to get facts from them. They don't agree with you, and they don't agree with you because they're witness for the other side.
Yeah.
The cop's never going to say, you know what, Mr. Nelson, you're right. Your client is not guilty. Your client didn't do that thing. I mean, you ever had that happen?
He didn't look drunk.
No, he didn't look drunk, or he didn't pull the trigger.
Yeah.
And so most of these people, they don't want to talk to you. And if you're talking to victims, they absolutely don't want to talk to you.
Sure.
You're evil. You're the bad guy. You're the one trying to help the person who hurt them.
Yep.
And so I think, when I'm in the courtroom, one of the things that I think about is, look, these are just people, and so I'm going to treat them like people.
Yeah.
And so I will often tell my clients, you will see me smile at the cop. You will see me laugh with a cop. You will see me make jokes. And I do that for a couple of reasons. One, because it loosens them up. It makes me more relatable.
Yep.
Not just to the cop that I'm crossing, but to the jury. It makes me a person.
Gives you some credibility.
It really does. And it allows them to relax. And if they relax, then this sounds terrible, but I can control them.
Sure.
I can absolutely control where they're headed better than if they're defensive and they're cautious and they're nervous.
And I think you just answered it, but in general, like, what's the benefit of control? There's a purpose to control other than to just be like, you're a controlling person.
Oh, sure. I mean, look, I've been objected to on cross and I've had prosecutors say, Mr. Dodd's testifying. I'm like, yeah, I am, 100%. It took you 10 years to figure that out, but that's exactly what I'm doing. Because when we're cross-examining, it's one more chance for us to tell our client's story.
Sure.
I mean, we get to tell it in an opening. We sometimes get to tell it when we're selecting a jury, or we should be telling it. We can tell it in closing. And on direct, when we're using our witnesses, we kind of know what the story is going to be, right? Because they're our witnesses, and so we've heard their story, and we know that it aligns with our story. But when we're cross-examining, it's one more opportunity to tell our story and not be locked into the story that the state wants to tell, that the Commonwealth wants to tell, that the federal government wants to tell. We're telling our client's story through their witnesses. And if the witness is relaxed, if the witness feels like, okay, I can talk to this person, or they just let their guard down, then it gives me more control over that situation so that I can tell the story I want to tell, not the story they thought they were coming up to tell.
Sure. And there's also, like you said, comfort, right? Because as we come there, I would imagine you've established your reputation amongst the professionals there in your community. But nevertheless, I'm guessing the cops kind of look at you, not necessarily side eye, but like, what's Matt going to do?
Oh, I mean,
they're not necessarily willing right away to just be open up. You ask them a question and you can see their gears rolling like, do I give them the answer that I think I have to give them, or is there some way that I can avoid this answer?
Sure. And I love it when we put them in that box, all right? We literally paint them into a corner.
Yeah.
And you give me the answer I want, or you can give me an answer that's going to make you look foolish.
Yeah.
Either one I'm going to win on.
Sure.
But it'll be easier for you if you just go ahead and give me the answer I want.
And those are going to be different with the times when we have either professional witnesses that just know it. They've been trained. They know how to do things. Or oftentimes it's also professional witnesses, police officers who this isn't your first time crossing them. You've crossed Barney Fife 7 times now. This is time number 8, and he knows about the other 7 times, good or bad for you.
And in small towns like yours or mine, absolutely.
Yeah.
Right. You have the repeat players, whether it's the cops, whether it's experts,
Yeah.
you know.
And sometimes that can be helpful, right?
Mm-hmm.
I mean, they might know I got to keep this tight because I know Matt. I know he can punish me.
Mm-hmm.
I know he's going to not make me look bad if I just give him the answers that I need to give him.
Yeah. And the other thing is, I mean, if there are times when it's okay to let your adverse witness save a little bit of face.
Yeah.
If there's ways you can give them to give an answer where they don't, their conception of themselves stays whole. They don't feel like they're betraying themselves. You know, they're going to be more apt to give you the answer you want to hear. They're not going to fight with you maybe quite as much.
Sure.
And if you're still getting the facts you want, and that's what we're talking about, right?
Yep.
If I'm going to ask Barney, hey, my guy's innocent, right? They're going to laugh at me. But if I ask a bunch of questions and I establish a bunch of facts and I collect all those facts up and all those facts together to shout innocence, then great. They felt like they did right by themselves and their department and their prosecution. But I've got all the facts that I need that I can trot out on close and say, folks, you heard from the cop, A, B, and C, and D. You heard everything. You know, that screams innocence.
Yeah. And that's story-driven cross.
Yeah.
I know recently when you spoke at NACTL, it was on opening, which to me is just story,
oh, yeah.
story.
That's right.
But when we give that story an opening, we need to pull those facts out in cross in order to tell that story.
100%. Because, right, your judges say the same as mine. Everything you hear from the lawyer, that's not evidence.
Yep.
That's argument. And, you know, if you get that objection in opening, and I don't know, there are some of those prosecutors that will object in your opening. And they'll objection, you know, that fact's not in evidence or some nonsense like that. And you're like, yeah, I'm going to get there.
Yeah.
No shit. Like, we haven't got to that point yet. But in cross, we get to tell that story. We get to pull those facts out. And we get to have the witness confirm the story that we're telling.
Yeah.
Yeah.
Maybe you said this in NACTL, but I've heard you say before, like you look at your trial work and maybe cross-examination, right? But you look at your trial work as teaching.
That's exactly right.
Yeah. Tell me a little bit more about that.
Yeah. So, I mean, when we go in, typically this is our client's first time to tell their side of the story. And we go second. They've already heard from the prosecutor, right? They've already heard the story, and it's usually a bad story. It's a story that's not helpful to our client.
Yeah. If it was good for us, we wouldn't be here.
That's exactly right. But, I mean, even before we get to trial, we're teachers, right? We're trying to teach the prosecutor why this is a bad case to bring to trial. We're trying to teach the prosecutor why this is a case that should get settled or dismissed. We're trying to teach the judge, if we can't convince the prosecutor, that this is a case that should never see the light of day, that should be dismissed, that should lead to suppression of evidence. That's what we're doing the whole way through, is we're teaching, I mean, we're persuading, but we're doing it by teaching, right? I mean, if I just tell you my client's innocent. You know, I was talking to a prosecutor the other day, and he's a newer guy and a very nice young man, and he said, I really appreciate the emails you send because you tell me why I should dismiss the case.
Yeah.
You don't just send an email that says, this case should be dismissed.
Your case sucks. Get rid of it.
Yeah, and I said, people send you that? And he's like, yeah, all the time. And you know what I do with that? I delete it. But I send him a couple of paragraphs and I'm saying, hey, you need to look at this piece of evidence. You need to look at this witness statement.
Yeah.
You need to look at the conflict here. Because when you do that, you'll see that what I'm asking for is actually pretty reasonable. It's not at all unreasonable that you give me this deal.
Yeah.
Or that you give me this dismissal. That you treat my client the way he or she should be treated.
Yeah. I mean, I've heard you say we learn through facts, not conclusions.
Yeah,
and,
that's
you know,
right.
even when you're talking, you have a couple of kids at home, right?
I do. Yeah.
I would imagine there's sometimes that you're in a situation where it might be good for you if you teach your kids something.
Yeah, 100%. I mean, my boy child is just as hard-headed as he can be. And if I just tell him, don't do that, you know, he's going to ignore me about 3/4 of the time. But if I tell him, don't do that because of A, B, and C, and D, you know, he might listen to me.
Yeah.
You know, even when we're skiing around, I say, don't jump off that cliff. You know, you're going to hurt yourself. And he said, it's fine. I've done it before. It's not that big. And then I'll go poke around the landing, and I'll say, well, there's rocks 6 inches below the surface. If you hit those rocks, you're going to rip your skis off, and you're going to go cartwheeling in the distance. And there's trees down there you're probably going to cartwheel into. And he's like, oh, okay. And we have to do the same thing with our jurors, right?
Yeah.
I mean, it seems so self-apparent to us that our client's innocent or that they should come back not guilty. And if we're doing our job well, I think we have convinced ourselves wholeheartedly by the time we get to trial that I don't even know how this got here. Because that's how we have to, if we don't believe it, then how are we going to ever get anybody else to believe it? But they're not just going to believe it when we say not guilty.
Correct.
We got to give them facts.